Any mention?
Those EVM matters, my lord, which came up yesterday, the 6 applications. So this is a mention memo, my lord, for withdrawal of the 6 applications. Separate mention memos.
Bring it in the supplementary list for withdrawal.
My lord, we are filing fresh applications with your lordship's permission under Rule 10, my lord. And we are making the...
Even the application for filing. You've looked at the Gautia good rules.
Yes, my lord. Though I may not agree with that opinion of Mr. Paul,
but that is even the Advocate General also that day when the matter came up, he said that since an absence of rules,
there's a judgment of Guwahati High Court also, my lord. I will
anyway.
My lord, if these matters can be taken up today, my lord. Slight urgency, my lord. Slight urgency, deeply.
My lord, I beg to mention.
I'm sorry.
No.
One more question. In terms of Rule 10, we are to present the application, the interlocutory application before this honorable court. So, my lord, do we present it to the court master or to the registry, my lord? That is the only question.
Present for a court master.
Court master, deeply obliged.
Yes.
Lordship, item number 24. Kamakshi.
24.
My lord. Senior counsel Mr. Paul is appearing for the petitioner, my lord, here.
Senior counsel who?
Mr. K. Paul. My lord, on 28 April, Lordship has directed us to correct the affidavit because there was no affirmation, my lord. So that will be done in course of the day.
There was no?
Affirmation in the affidavit, my lord, defective, my lord.
Yes.
So we are doing the correction today in course of the day.
After how long you doing the correction?
No, my lord, on the last occasion, I have prayed 4 times. There was some difficulty, so we are doing in course of the day. We'll be serving the copy to them also, my lord. Advance copy will be served.
That come up for 3 weeks now.
My lord, highly obliged.
Yes. MSR only submits that the defects in the affidavit will be corrected in the course of the day. Stop. Not objected to by the counsel of the petitioner. This is matter of stop. Next line. This is a matter of 3 weeks. Yes. And so on. So.
Lordship, I beg to mention item 31 and 32 on behalf of Mr. H. Abraham.
31 and
32, Your Lordship.
You have objection?
No, Your Lordship.
Okay, 3 weeks. He's not here today.
Your Lordship, he is out of station.
He's as Iron Counsel, as the GA, arguing the matter. As Mr. H. Abraham, Iron Counsel out of station. Prayer made on behalf of adjournment. Stop. According, this is a matter after whatever weeks. Yes.
Lordship, similar prayer for item 38. Lordship, I need some time to prepare.
You have objection?
No objections, Your Lordship.
3 weeks on the prayer of Ms. Tungwa. Due to personal difficulty. Yes.
Vice Lordship.
Your Lordship, I beg to mention item number 34.
Who's for the petitioner? 34. For Kongliar.
Yes, Your Lordship.
Who's for the petitioner? You've informed them?
No, Your Lordship.
Then?
Your Lordship, I'm appearing on behalf of respondent number 3.
Very good, but have you informed the petitioner?
No, Your Lordship.
The courtesy demands you inform the petitioner at least. Yesterday, who made the senior counsel wait the whole day? Who was that yesterday, counsel? Who made Mr. Khoti wait the whole day? Then when the matter came up, took adjournment. You informed them? 3 weeks. Informed by telephone? Yes.
Please, Your Lordship, I beg to mention item 35. The conducting counsel is out of station. We have already informed the opposite parties.
3 weeks, yes.
Highly obliged.
Please, Your Lordship, I beg to mention item number 28 and 29. The conducting counsel is out of station.
Who's the conducting counsel?
ML Nongpure.
He's out of station?
Yes. I'm for respondent number 2.
You informed the other side?
Yes.
28, 29?
Yes.
No urgency. Who's for petitioner? No urgency in this matter? Okay, 3 weeks, yes. 3 weeks, yes. Yes.
I also beg to mention item number 30, Lordship.
30?
30, yes. 30.
30?
Yes.
On whose behalf?
ML Nongpure.
Where's he gone? Out of station.
Petition.
For respondent number
Now we have some objection.
Positively next.
3 weeks, yes.
Right.
Mr. Marpan, though not objecting, praise the matter be positively, praise the matter be taken up for hearing on next week, yes. Next date.
Okay.
Lordship.
Lordship, I beg to mention item number 26.
On whose behalf?
Ms. S. Bhattacharjee, she's on sanctioned leave.
And for the petitioner, Your Lordship, in this 25 and 26 are connected matters, Your Lordship.
So you have objection?
No objection, Your Lordship.
26 after 3 weeks also.
Obliged.
Yes.
Your Lordship, I beg to mention item 27, Your Lordship. If this matter can kindly be taken up after 3 weeks.
No objection.
Yes, 3 weeks.
Much obliged.
That's it.
Lordship, I would like to mention item number 21. We seek 2 weeks' time due to Ms. Bhattacharjee's uncle has
Due to
expired.
bereavement of the counsel for the respondent number
7.
7, this is matter of the 3 weeks, yes.
Lordship, I beg the same prayer for item number 23.
Okay, 23, yes.
Obliged.
May it please, my lord, I beg to mention item number 17. Are we filing
17?
Yes, my lord.
17 isn't the, no, it's order, don't mention order matters.
Yes.
Let it come up. Yes.
Item number 1.
Where were you last time, Mr. Bora?
Actually, I got late. I
Where's
reached
Mr.
late
where's
due
other
to
side?
traffic jam actually.
Where's the other side?
Mr. Nongbreeze,
He was here just now.
yes, here just now. They have filed a affidavit, I have received it. Today was for hearing.
Yes.
Will be coming, Your Lordship.
You filed objection to coordination application. Where's the objection? Have you filed it or not?
Yes, Your Lordship.
I have received a copy.
Yes, take it out.
Can you
What's
pass
the
over, Your
objection?
Lordship?
Only for number 3. What about 1, 3, and 6? Yes. Yes.
Can you pass over, Your Lordship?
Pass over for what?
I'll be handled by my senior itself.
Where's the brief? You don't have a brief with you.
Sorry,
So junior is supposed to hold a brief for the senior colleague. This is matter after 1 week. Yes.
Item number 2.
As the counsel for the respondent is unprepared with the matter. Yes. Yes.
My lord, the correction has been done.
Fellow objection.
You'll file. Yes, Mr. S. Marpan's, this is condemnation also.
Yes.
First record, Mr. P.K. Bora, learned counsel for the petitioner, submits that the typographical errors that have occurred in the application have since been corrected. Stop. Next paragraph, Mr. S. Marpan for respondent number 1. What about 2? He'll be filing objection also. And MS D. Mauri, right? For respondent number 2. Pray for allowed 2 weeks' time to file objection to the coordination application. Just thereafter, and so on. So, you have any other responding appearing? Only you. Or you'll file also. You already filed. Number 1, number 2, D. Mauri, and number 3, Mr. H.R. Nath. Pray for allowed 2 weeks' time to file objection to coordination application.
3.
My lord, in this case, we are supposed to file rejoinder. But after going through the record and everything, I found that's
Not necessary.
not necessary. We'll go for hearing.
Mr. H.R. Nath, learned counsel for the petitioner submits that on going through the affidavit filed by the respondents, no rejoinder is necessary. He prays the matter is for hearing. Accordingly, next para lists the matter for hearing in usual course and so on. So on.
4.
Yes, Mr. Shilla.
Please, Lordship. Lordship, I'm appearing for respondent 5 to 7, 10 to 13. I pray that time.
One second. Nobody responds are there. 5 to
7, 10 to 13.
And
10 to 13.
What about 8 and 9?
We are not appearing for them.
The same party?
Lordship, I have not. I don't have instruction to appear for them.
So 5 and 7 is it? All right. 1 second. You do one thing. You just the status not been received in 8 and 9. You obtain the status of service. Okay. Yes, Mr. J. Shilla is present today on behalf of the respondents 5 to 7, 10 to 13, and prays for further time to file. First time appearing?
No, second time, Lordship.
And prays for further time to file the affidavit. You already filed yours.
Yes, Your Lordship. 124.
Next paragraph. MSZ Inaugury submits that the affidavit on behalf of respondent 124 has already been filed. Stop. Next paragraph. Office note indicates that the AD card in respect of respondent number 8 and 9 is yet to be received. Stop. Counsel for petitioner to obtain status and file service affidavit. This is a matter after 2 weeks. Oh, you want 3 weeks?
3 weeks.
3 weeks.
5.
Please, Your Lordship, this complete our pleading are complete, Your Lordship.
Yeah, we have received the rejoinder, my lord, and we have nothing else to say, so we'll go for hearing.
Party submit the pleadings complete upon this matter for hearing. Usual course on so.
Right.
6.
I'm praying for further 2 weeks' time, my lord, for the affidavit.
How many times you asked?
5 or 6 times, my lord.
5 or 6 times?
I'm praying for 2 weeks, my lord. It's prepared.
5, you already serve a copy to Mr. P.K. Sama?
No, my lord, not yet. 2 weeks'
What
time,
about
my lord.
Mr. Chanda?
Weeks' time, lord. We are on it,
Mr. S. D. Learned Counsel for Respondent 1 to 3 and Mr. S. Chanda for Respondent 4 to 8 for the 2 weeks' time to file affidavit. Stop. It is noted that repeated extensive time has already been granted to file affidavits. Stop. However, in interest of justice, further 3 weeks' time is granted. Stop. It is expected next year the affidavits of all the respondents should be on board.
Must rest, Lordship.
Enough time, 3 weeks to file it.
Not positive.
Mr. Bora, you moved the matter, next day nobody appears, and you didn't even take steps for service of notice on the respondents.
My lord, the notice sent in by registered post also came back saying that the address is incorrect.
How do you send it by yourself?
Yes, my lord, to stick steps.
You should send it through the registry. I mean, you deposit your stamp in the registry, they will send it. Then
we filed Talabana, it was not accepted because there was no order specifically that Talabana has to be filed. Talabana was refused, so I sent
steps have to be taken. Steps have to be taken. What Talabana? Yes, officially the steps have to go.
Earlier order was for sending by post.
No, steps were taken 1 week, but it's 80 upon sole respondent. Issue notice at the time you moved it. That was on 13/4/2023.
No, ultimately,
take down, yes, Mr. P.K. Bora.
It has come that the address is wrong, it says. Now, this person has been suing the cases there in the district council court also from the same address.
Naturally, you send it in the personal capacity.
It has come back. That means he is avoiding the notice.
Okay,
so I may be allowed to publish the notice in the newspaper.
No, not at this stage. Mr. P.K. Bora, then a counsellor for the for the petitioner submits that at his own initiative, notice on the registered AD was taken for service or for service on the respondent, but the same has returned unserved for want of correct address. Stop. Next paragraph. The council petition therefore directed to take steps in the proper manner through the registry, and it's also permitted to effect personal service if need be within 2 weeks, just thereafter, and so on. So.
Item number 8.
Okay, my lord, I readied the rejoinder. I'm waiting for the signature of the petitioner. I'll be filing it in the course of the day today.
Mr. Bora submits the rejoinder file in the course of the day. Yes, this is matter up to 3 weeks for hearing.
State is a formal party.
9.
Yes, Mr. Namkla?
Lordship, the respondents are yet to file affidavits.
Lordship, I pray for more time to file affidavit.
When was the matter filed? How many times have you taken?
This will be the 4th time, Lordship.
Okay.
On behalf of
Your
Mr.
name?
E.R. Khan.
Mr. E.R. Khan, Vice Mr. H. Abraham.
H. Abraham.
Praise for and allowed. What about the other 7 and 8? 7 and 8 was appearing 7 and 8.
District Council need not file, I believe, because they are just
Okay,
mere
then
party.
Mr. So-and-so, Vice also praise for and allowed for a 3 weeks time to file affidavit on behalf of respondents 1 to 6. Just
Obliged.
thereafter and so on.
10.
I'm praying for some further time, my lord, to file the affidavit. I'm praying for some further time to file the affidavit for respondent 1, 2, and 3.
Lordship, I'm appearing on behalf of respondent 4 to 8.
You file the affidavit?
I'm praying for the 2 week time to file our affidavit.
Mr. S. Day, no objection?
No.
For respondent 1 to 3 and MSE 1M for 4 to 8, pray for and allowed further 3 weeks time to file their affidavits, just thereafter and so on.
Your Lordship, in this case, an interim order was there. Yes, Your Lordship.
Interim order when he shall continue until the next day.
Obliged, Your Lordship.
11.
May I please, Your Lordship? Your Lordship, I'm praying for some more time for respondent 1 and 2, Your Lordship.
What about the remaining respondent steps?
Lordship, I'm appearing for 3 and 4. Accept your vote.
Yes, what's your full name?
M. Prasad.
M. Prasad, your full name?
Mahadev Prasad.
Mahadev Prasad, okay. Mr. M. Prasad has entered appearance today on behalf of respondents number 1 and 3.
3 and 4,
sorry. As such, the service is complete. Stop. Next paragraph. MS Eiling on behalf of 1 and 2, and M. Prasad on behalf of the other 3 and on the behalf of 3 and 4. 1, 3 and 4. Pray for and allowed 3 weeks to file the affidavits.
Obliged, Lordship. 12.
Items 12 to 15 are similar matters. The petitioners are claiming the retirement benefits who are working for the corporation. May I pray for 5 months' time?
In all the matters. 5 months, all right, Mr.
All the matter.
Let it be 3 months.
Let it be 5 months, otherwise it will come again for extensions.
Okay.
We'll pass orders. Yes.
All right. Obliged.
5 to 5 to
15.
12 to 15.
12 to
16.
Okay.
On the previous date, Lordship was pleased to issue notice on all the respondents. And Lordship, today I
pray that I may be given some more time to file my affidavit in response to the petition.
What's the matter about, Mrs. Sama?
Regarding
Pension?
not pension, it is 100 hectare.
They had changed the SOP for mining.
Regarding the mining SOP?
Yes, SOP.
Yes. You're appearing for? 6. And what about 5?
Lordship, I'm appearing for respondent number 5 KG.
And you? 7 is? That means 6 is Giant Hills. Okay. How much time are you praying for?
Lordship, 3 weeks time.
Mr. H. Karwan Lang, additional senior government advocate for. You are additional senior government advocate.
Lordship.
For respondent 124. MS C. Nongklaw for R5. MS Rumthau for 6 and Mr. Dave for 7. Pray for allowed further 3 weeks time to obtain instructions and to file affidavit. This is the draft one so and so.
17.
Please.
Wait, please, my lord. I appear for respondents 1 to 4 and I seek 1 week's time to file my affidavit.
Lordship, we have already taken steps for respondent number 2 and 5, my lord.
What about Mrs. application?
This application, my lord, that is what. Pressing on this application. Lordship pass an order.
It would be resolved with in a week's time once I file it.
What's the miss case for?
To stay the order, my lord.
No, of course. What's it about? What order?
Order is at annexure 3, my lord, page 21.
Your Honor,
This is the impugn order which we are challenging, my lord.
Your
You're
Honor,
saying
this
that it's a reserve post, my lord, which has been given to the private respondent number 5, my lord.
Your Honor, this was a transfer made. The post of the peon.
It's all right. You understood. MS S. Sham, Leonard Counsel for the respondents 1, 3, and 4. Place 4 is allowed. 3 weeks time to file affidavits. What about the steps not received?
Not received, my lord.
2 and 5 received back.
Lordship, but they have not appeared, my lord.
Office note indicates that the service is complete on respondents 2 and 5. Yes, form no minute, So next, accordingly, this is matter up to 3 weeks for affidavits and for appearance by the respondents number 2 and 5.
This case, my lord.
This case, we take it up next time because if she file affidavit, say it clear everything.
That should resolve the issue. Oblige, my lord.
Hello.
Hearing, item 18.
May I start, Your Lordship?
Why did it stop?
May it persist, Your Lordship. Lordship, in paragraph 6, Lordship, can you come to the affidavit filed by us, Your Lordship, at para 6, Your Lordship. Para 6, Your Lordship. We say that since there is a restriction in creation of a reclock post,
that is what you're supposed to come up with.
Lordship, Lordship, that is why, Your Lordship, I brought it. Lordship, this is the office memorandum dated 17 July 2011. May I read it, Your Lordship?
Yes.
This is the office memorandum dated so-and-so, subject economy measures and special economy measures in expenditure both under plan and non-plan during 2011-2012. The undersigned is directed to say that the austerity economy measures and instruction contained in this department memorandum, office memorandum number so and so, will continue to remain in force during 2011-2012, and until further orders, it is reiterated that the instruction contained therein must be strictly followed. Subordinate officers under your respective administrative control should be instructed accordingly. Kindly acknowledge. And then, Lordship, kindly turn to the next letter, Your Lordship, that is 19/1/2011.
Why didn't you attach this in the affidavit, Mr. Lordship? Now it just delays the matter. You'll have to file a affidavit now.
Lordship, let
if
me
you want to
file
go to take
a small
cognizance.
affidavit, Your Lordship.
Yeah,
I'm sorry, Your Lordship. I'm really sorry, Your Lordship. It's
responsible counsel. I mean, it is Mr. General has to be given,
yes.
Everything, all the cards should be laid on the table. What do you say, Mr. At the time the hearing commences?
So let me file by now.
Put them to a disadvantage. The whole, that means the whole angle of arguments have to change also. What will be the impact of this?
I'm sorry, Your Lordship.
What do you say, Mr. General? Is that correct?
That is true, your Lordship, even on the face of this.
Whether this is sustainable in, in its current, in the form
Moreover, your
take down, yes, on the query of this, when the matter was taken up for hearing on the last date, on the query of the court with regard to the moratorium,
Lordship, yes.
with regard to the averments made in para 6 of the affidavit, that there was a bar on fresh recruitment, Mr. Andy Shulai, learned EAG, has produced an office memorandum dated 17 July 2011, which contains the set restrictions. As this memorandum has a bearing in the adjudication of the matter, he is directed to file the same by way of affidavit,
Lordship,
to enable the petitioners to respond to the same. Yes. When will you file it? You file it within 1 week.
1 week,
yes. This the matter after it's been filed.
Lordship, I may be given liberty to reply to that.
Of course. Yes. That no need to say that.
So let me take back, sir.
You have given.
Okay.
Let me go through.
How like your Lordship?
20.
Yes, Mr. Prasad.
Let this matter may come at the bottom of the board, Your Honor.
We already at the bottom of the board, Ms. Kumar. How many matters left?
40, Your Lordship.
No. How many matters have asked the court master?
Mostly adjourned.
Where is Mr. Guru?
Because of some personal difficulty, he'll come, Your Lordship.
14 items have been adjourned.
Then we'll take it after 3 weeks. That time you'll be prepared.
You want to take up today's only?
They should be here. Sorry. This court, it cannot be at your convenience.
Yes,
It's going to be the entire public.
Yes, Your Lordship, I understand.
Yes.
22.
Kind of bless Your Lordship.
Please, Lordships. Lordship, I appear for Respondent 1 and 2. I've been informed, my lord, that there are talks of settlement which are going on. This is regarding the implementation of the pay commission. And another issue, my lord, which is there is that out of the several petitioners, my lord, few of them have since retired or resigned. No, they have resigned or they have been terminated. More specifically, my lord, petitioner 1 and 2, my lord. Petitioner 1, Fleming B.
Petitioner
Marak.
1 is Fleming B. Marak. He's retired.
He is resigned.
He resigned.
Resigned.
Is that correct?
Lordship, he has taken a voluntary retirement.
Okay.
Then
Resigned.
that petitioner number 2
is terminated, my lord.
This case was still under here. He was terminated. Of course, the case is pending here. He is challenging this termination.
Okay,
the rest others are still
Others are there.
there.
Number 2, that's Sinora.
Yes, my lord.
petitioner number 1 and 2, of course, one already taken a voluntary retire, another one terminated, but his termination is still pending.
So should we strike off these from the list?
Lordship, we can strike off this.
Two names.
Two petitioners. Rest are still working.
You do not dispute that the one is taken VRS and the other is because there is no documentation. We're just accepting your submission at the bar.
Yes, Lordship, there is no disputing. He has taken the voluntary retire. Petitioner number 1 taken a voluntary retire.
And number 2 terminated, and which is challenged. That's not a problem. Yes, Mr. P.T. Sangma at the outset submits that the petitioner number 1 has since retired, hasn't taken voluntary retirement, and that and petitioner number 2 has been terminated from service, for which independent proceedings have been instituted.
And the case is pending here also. Yes,
you don't need to say anything. Stop the next paragraph. Mr. S. Dev does not dispute the submissions made by the counsel of the petitioner. Accordingly, the names of respondents on 1 and 2 shall be struck off from the array of parties registry to do the needful. Yes, and on the other part, you see?
My lord, my instruction is that there are talks of settlement because this is for implementation of the 5th Pay Commission. So, in fact,
regarding that, I have no instruction, Lordship. That's very clear. Since this implementation as per the Annexure 1, Your Lordship, page number 16, Lordship. May I just say? Yes. This is the resolution made by the executive committee themselves, and they have amended and they have approved. This very clearly said that the executive committee, Council Tura, is pleased to approve and endorse the Meghalaya government resolution on the recommendation of the Pay Commission, white number so and so, dated Shillong 28 November 2007, which is making applicable for implementation of Meghalaya Pay Commission in JZTC with effect from 1st January 2017. Now it's already been done in the year of 2017. Till now,
18.
Yes, 18.
With retrospective effect from 17.
Yes, Lordship. So it is from 19.
No, but if they are planning to implement it, they're having severe resource crunch.
In the affidavit also we have stated right from the very beginning, my lord, that we are trying to implement it. In fact, they have already.
I don't think there's any question of trying because I think you're bound to implement it.
Yes, so they are, my lord, figuring out the process. In fact, because already salaries were released in the previous pay scale, which they have accepted.
No, they have released the salary, they have been releasing, and we are getting the salary even in the old scale, not as per this.
Correct, you'll get arrears.
We are trying to settle it, my lord.
You want to argue the matter?
The matter means my only simple submission is that they should implement and pay the salary as per their approval order, Lordship. That is the only because
that's all right. You take down. The matter concerns the implementation of the Meghalaya 5th Pay Commission to the employees of the District Council.
Lordship.
Stop. Mr. S. Deb submits that the entire matter is under consideration for release of the set of for implementation of the 5th Meghalaya Pay Commission. Stop. He praised the matter be tabled for 6 weeks. He aims him to obtain positive instructions.
Lordship.
This is accordingly.
After 2 weeks, Lordship, because
they cannot do anything. Give them 6 weeks. Then you politically you go and you can go and try to get them to sign the fresh orders.
33.
Obliged, Lordship.
Much obliged, Lordship.
Yeah.
33, my lord, is a matter of school managing committee. The main issue, my lord, is that whether the administrative authority can review its own order. And
who's the member of the state?
State, my lord, Mr. Bhattacharya and Mr. Qureshi was there for the school managing committee, my lord.
You're sleeping?
Your Honor, I miss out, Your Honor. Lordship, today the conducting counsel is not well, Your Lordship.
Who's for the state? Is it directing against the state or against the managing committee?
It's in fact against the state because the SDSU, upon assuming charge, has reversed the order of the previous, my lord, without any.
Mr. Gurung only. Yes,
Only I pray for some, my lord, because appears that they are trying to make the matter infructuous because managing committee will expire in the coming months.
When is it going to expire?
It expires in 31st of October, my lord. Of course,
Yeah,
some
but
time
that's
is
fine.
there.
Yes,
Your Lordship, I
prayer
had got...
made for adjournment on behalf of Mr. M.F. Qureshi, appearing as one of the four to be indisposed. So none appears on behalf of the state. This is a matter of after 3 weeks. Yes. Yes.
Obliged, Lordship.
Highly obliged.
36.
Lordship, I was there for the state.
I didn't see you, but we are asking for the state. Then you record her name. Yes.
Lordship, I pray that this matter may come at the end of the board, Your Lordship.
We already ended the board, Mr. Karim. You have any objection to this?
Lordship, we just received this message today, Your Lordship, so we need some more time, Your Lordship.
We already passed order status quo. What change do you want? What change do you want order? Why?
I think, my lord, in this affidavit, my lord, there was something with regard to something wrong with regard to this paragraphing, my lord. There was nothing on record. The only thing which they had mentioned was of knowledge, even though some paragraphs can be.
No. Your application is for, instead of status quo, to write stay.
Oh yeah.
Or application stay or impugn notice intended to say there is 15.5.
This one.
This is the
I'm
old
sorry,
one.
my lord. Oh, sorry. I'm sorry, my lord.
What's wrong with Mr. Thapa?
Yes. My lord, here in this application, my lord, what had happened is on 2 occasions there was a status quo order granted by this honorable court. And again, my lord, there was...
Where is that 15? Where's that 15.5?
Your lordship, the 15.5 order is page 14, my lord. Now, in spite of the status quo order and the undertaking given by the council, that...
This one is computer generated, these notices?
Yes, your lordship.
There's a problem with the systems, because they're running independent of each other. So unless if the court orders factored in, it generates, when the time comes, it's like that.
Your lordship will see...
I've talked to some expert people that time. It is sometimes, these show cause notices, infraction notices, even though the person has filed already a representation, it's still generated, by the system. And another section of the office just issues them.
This one we had received through post, my lord. This notices we have received.
This was
through
dated
post.
when?
This is 15.5, yes.
And the order for status
order
quo
is to date 3.5. Your lordship will find at page 9, annexure 1.
Yes.
Paragraph 3, your lordship, which is at page 10. It is, I'll read the...
Mr. Datta undertook last time shall not be implemented.
And he again goes on to say in the other order, my lord, which is at page 11, 18.5. Even the operative portion is at page 12, your lordship.
Yes.
He para 3, my lord, he says he therefore undertakes that the order passed by this honorable court will be complied with till disposal of the writ petition. Now, even after this, my lord, they come up with this.
That is what is 15.5. Where's Mr. Datta?
Your Lordship, he said he is not feeling well.
You do one thing, you get instructions, we'll listen tomorrow. On this case, okay? You obtain instructions. Because if the undertaking is there, what is this? What affidavit is this?
This is in this case. There are 2 Mabanium projects fixed today, my lord.
Who's Eslalu?
No, this is another case, my lord. This is page item.
Oh,
item 40.
No, mistake given by her. Item 40. Okay.
Obliged.
List this matter tomorrow in supplementary list to enable MS. Your name?
P. Ratam.
Yes, P. Ratam, to obtain instructions from the arguing counsel, who is not present in court today. Just he can appear hybrid also, no problem. But then there'll be a stay because if his undertaking is being given, so it's he will not dispute also.
Absolutely.
Just for your past order, when he's not there, then tomorrow.
That's 7.
That is, Your Lordship. That this matter may come after 1 week, Your Lordship.
No objection.
A. Sama prays that the matter be adjourned for today due to personal difficulty. Please allow this is matter of so and so.
39.
May it please your lordship.
What additional affidavit you filed, Mr.
Oh yes, your lordship. This is the we filed the affidavit as per the order passed by this.
What affidavit? What do you see in the affidavit?
Just the report given by the respondent 1 to 3, your lordship, as on the basis of the meeting that was held on the 28/5/2022. I'd just like to draw your kind attention, your lordship. First, addition that affidavit, your lordship. Before we go to the merits of the case, your lordship. A report on the meeting of the Darbar of Laj Nongrim. Now we're talking about the bifurcation which has not been done as per the Act. So now we'll come to that, your lordship.
You served Mr. Counsel?
Yes, your lordship.
Where's Mr. Kanta?
He's here, Your Lordship. He's come.
Check the meet copy.
Number 4 is whom? You ready with the matter today? Number 4 is whom? Number 4 is Errol Waljara, so acting CM Himanung Spung. Who is appearing? Acting CM. Now the full CM's come back. I think I saw notification somewhere. That correct, Mr. Kanda?
Yes.
Now it's acting CM who Nong Spung or the old Nong Spung's been old CM's been restored.
I think it's
been restored. Huh? I mean the old CM has been restored.
Who is appearing for you're ready?
Law number.
At the time that it was acting.
Who was acting that time?
During that time, your lordship. Yeah. The time we were aggrieved about
Is he an important respondent or no?
No, he's the one, very important.
He's the one.
Yes. He's the one, your lordship.
The acting CM.
I don't know how he interfered also into this case. I don't understand. What jurisdiction he has got also.
You're still appearing for acting CM or the full-fledged CM?
The acting CM, Your Lordship.
Then he's been restored as per Mr. Kanta, that's what he said?
No, I have no idea.
No, I've come to know he's been restored. I mean the original, but that's...
I have no knowledge.
In this case, but...
No, how can we proceed? If the acting CM is there, that means you're out of the picture now. It's by office. Yes, acting or full-fledged CM, the CM is the CM.
Yes, yes.
I think he has to get instruction.
You get instructions. Because I thought I saw in the newspaper about
I've seen.
You are the fountainhead of this council. How can you miss out? The order comes from your advice.
Anyway.
You were ready to argue the matter today?
No, sir.
Then? I like all your attitudes. So, relax.
For me, I'm very much interested to pursue the matter.
Of course, you're a petitioner.
Yes. Highly agree with you, Lord. Injustice has been done.
We can make out this.
Yes, I can make out the entire all the matters.
It appears that there's some instruction that's free as to whether respondent number 4 is still in office or not. Mr. Vijay to obtain these instructions to apprise the court. So also the counsel is present today in behalf of number 4. This is matter after 3 weeks. This court won't be here for around 3 weeks, so we can't list the matter before that.
Lordship will be here till which date?
I'll be here till, day after, I think. Maybe.
Day after.
What team?
Actually.
Highly obliged. Yeah.
You're not correct. Yes, sorry.
We have just received the affidavit.
Lalu, because this is the affidavit
This is the
file that was
affidavit.
given.
So we have just received it today, Lordship. I'm praying for some time, Lordship.
What do you see in that? What does it say in the affidavit? Why? What affidavit? This is to be on record. What? Or just an affidavit?
No, Your Lordship. To bring on record the order dated 6.
They have raised the question of maintainability.
Okay. Mr. S. Chandas submits that an affidavit has been filed by the respondents 1 to 6 today itself.
Today itself.
Some time is required for obtaining instructions. According to this matter and so and so.
Worship like that.
Hello? Where's Mr. Philemon Numbri? Ready? I'll just take a request. When they will inform, at that time we'll reassemble.
Supplementary list.
Yes.
Item number 1.
But all these items, my lord, these are for withdrawal, my lord, with liberty to file afresh, my lord. These are those applications filed for EVMs, my lord.
Oh, this one that. Yeah, I agree. What's up here withdrawal?
This case number, my lord, 3 of 23 is for withdrawal.
Oh, withdrawal, you didn't file application?
No, my lord. By mention memo.
Anyway, it's we don't let's not get too hyper-technical with the withdrawal. Can't this defeat substantive justice? So where's the list? That means item number?
Item number 1 to 6, my lord, all of them, my lord.
And the other items are listed also?
Yes, my lord. All these matters I have filed fresh. Withdrawal in view of the objections, my lord, that we have to file by permission of the court, which I have given separate mention memo, my lord.
No. Now, where's the fresh application then?
Fresh applications are there.
Just presented before the. You presented before the.
Court
Before the court. Thing is that it should be sent to the stamp reporter. Anyway, we'll do that later.
That can be done later.
That's all right.
That leave has to be granted by your lordships.
Yes. 1 to 6. Since this one is a small technicality, we will get it over with. Let's not get bogged down in hyper technicalities. This application has been filed for withdrawal of the instant business application on the grounds set forth therein. On the ground that, what was the ground?
To file a fresh, my lord, in view of the objections.
On the ground that, in view of the objections raised by the, who are the, by
respondents,
by the other parties. Tom, no, sorry.
This all botched.
This application has been filed.
Application for withdrawal has not been filed.
In view, not on the ground, in view of the objections raised by that party, with liberty to file afresh. Stop. Matters prayers already allowed. Matters stands withdrawn as prayed. Liberty withdrawn as prayed, with liberty provided that the fresh application be presented for consideration. Yes.
That's
all 6 matters. And the fresh matters.
Fresh matters, my lord.
Have you served copy?
Yes, my lord. All the parties who've till date been present.
Is as per the rule 10 of the Godly Good rules?
Yes, my lord.
Yes.
So, my lord, in election petition number 1, my lord.
Okay.
Since we are parties in this matter, my lord, with your lordship's permission, we have filed this application.
Who's appearing for the other?
Mr.
Kartush. No. Kartush is the petitioner. Kartush is the petitioner or the?
Kartush is the return candidate.
Who's the return candidate?
Kartush.
Number 2. Number 1, John Marag is?
He is the petitioner. The
You're the
election
petitioner.
Yes.
You have no objection to this petition, no? Yes, this application has been brought before the court. You're seeking permission to release the EVM dash nota VVPAT machine from the strong room, as the same is not a subject matter or an issue in controversy in the connected election petitions. Registry to register the instant business application in the set election petition number 1 of 2023. Then next in the same order, so then that's same case, another order. Yes. Consider the prayer. There'll be 2 orders. There'll be 2 orders in one case, because they'll take it, register it, so we won't have to come sit again. Then the second order will come there. The first order is directed to register the miscase in the election petition. Now, next order in the same case, seen the prayer made in the business application. This will carry a number, which is not disputed by the counsel for the petitioner or for the return candidate, response 1 and 2 respectively. Accordingly, the prayer as made out in the application is allowed, and the EVM-BVP-AT machine is directed to be released, for further use and transportation by the applicant, Chief Electoral Officer, Meghalaya. Yes, that's number 1. Yes.
Election petition number 2, my lord, we are not parties, so therefore we have filed 2 applications. Yes. One is for intervention, my lord, and the other is for directions.
First one, there will be 2 orders. Now, second one will be thought of order. This is an application under Order 1, Rule 8, capital A of the CPC for limited intervention by the applicant, Chief Electoral Officer, for appropriate orders which have been made out in the accompanying business application. Stop. The said intervening application is allowed. Registry to register the intervening application, which stands allowed. Yes. Now next one. Next one is same order as on VPPTAC. Yes, Mr. Sai.
Just a slight intervention at this point. Section 82. Because the implement applications, Lordship, in my respectful submission, would be squarely contrary to Section 82 of the Representations of People Act.
No, 82. We should have said that before. 82. Intervention application.
Yes, Your Lordship.
It's not for impleading.
Just for intervention.
But even for the purposes of participating as a intervening party, because the parties to the petition, a petitioner shall join as respondents to his petition.
Where are you reading?
Where the petitioner in
Where are you reading?
To Section 82.
Section 82.
Okay.
A petitioner shall join as respondents to his petition, where the petitioner, in addition to claiming declaration that the election of all or any of the returned candidates is void, claims a further declaration that he himself or any other candidate has been duly elected, all the contesting candidates other than the petitioner, and where no such further declaration is claimed, all the returned candidates, and B, any other candidate against whom allegations of any corrupt practices are made in the petition.
Why do you say that it runs contra?
Lordship, because there is no contemplation under Section 82 of a party other than the 2 specified under category.
No, you see, the thing is that Chief Electoral Officer should not be a party at all. Number 1. They should bring an application striking him off. But they require some order to release the machines. So who will file an application? So they have recourse to, if the election operations be taken as close to CPC as possible, where there is no provision provided in the Representation Act, so what recourse will they take?
I'll leave it at that, but the only thing that
you cannot get hyper-technical. Now you say that, there are only 2 parties, that's correct. And earlier, to my memory also, whenever Chief Election Commission or Chief Election, the first thing when any election petition is presented, comes to court, we file the striking off. And so it's struck off. And so the list is between the return candidate and the person challenging the election. So it remains like that, goes on because evidence is led. And only in cases where exceptional cases where evidence has to be taken from an expert kind of opinion, then we call the officials of the Election Commission. So in those cases, that's different. They're coming as witnesses only, not in the official capacity. Right. In this case now, because there's no provision in the Representative People's Act with regard to intervening for this limited portion, because it's not in question. The EVM machine, they don't object, it's not in question. It's not an issue. So then we have to pass appropriate orders, yes.
I'll leave it at that. The only issue is that so far as the retention of the VVPATs in the strong room is also concerned, that aspect of the matter may not be automatic on the filing of an election petition.
No.
So in
It's not
that-
automatic. That's why it's come an application. If they are an issue, suppose like in the other matter, I think Mr. Paul's appearing with regard to that mock vote where it's still retained in the EVM machine. Then naturally we can't release that machine. It has to be examined by experts, sent to the laboratory, whatever. So that is the anyway. Yes. In fact, just to recall, that was in the which elections was that? Maybe when the first EVMs were used.
18
also. And then that time I was, Council for Election Commission of India. So we faced the same situation where the entire machines were locked up. They were, and so we had to move a special application, and this whole rigmarole had to be gone into. And finally, because the judge who was sitting election commission at that time was very adamant about releasing anything. So understanding the difficulty we face. So I'm looking very compassionately. So that's the thing. He must have Paul knew who was the election.
I was again for the election.
Yes. Could not make him understand as to why, isn't that an issue? So anyway, pass some orders for release of EVM BP machine, yes. Next item.
My lord, election petition number 3, my lord.
We have party there?
We are parties, my lord. So only one application has been filed.
Party, then there's 2 orders. First order, registry, and the other one is for release of machine. Yes.
This is lucky brother.
Objection, okay.
No, Mr. Paul, let us, one thing is that I don't want to make too hyper-technical. Because election law, as you well aware, to go hyper-technicality, it defeats the entire purpose. So we will try to, adhere to the basic trial court, filing applications, you need something, you file an application, you file your appearance. So those things fine as close if it's possible for trial, and that's it. Other things we can iron out, but that is subject to the parties, So because objections can be raised, like CPC is the jungle. You can ambush anyone, anywhere, anytime.
Only one legal issue is coming to my mind. Of course, I'm not pressing it into service here. Well, it's application under Order 1, Rule 10, whether the applicant will be entitled to any substantive relief in an application and in a proceeding where he's only appearing as an intervener.
No. It's only limited. It's limited to intervening only for this one.
Well, which is why I said that at this stage, because this will open up a Pandora's box, so I will not really get into that.
That is not an issue in this election petition.
And this one, Melody, here we are only concerned with the affidavit.
Yes.
So election petition number 4, Melody, we are parties. Melody.
Number 3, you're not parties.
Number 3?
They are parties.
They are parties. Number 3,
also parties?
You write same order as where they already parties. You have Dr. Burra 180, as where not parties, intervening is allowed, registry to register. Then?
Election petition number 4, also, Melody, we are parties.
Mr. Paul's matter is one machine that is only matter that needs a
number 6, Melody, item 6.
Yes. Number 4.
Number 4, Melody, who's appearing?
Your party is there.
Yes, Melody. She's the election petitioner. We are parties.
The petitioner is Tonang Shira.
Yes.
Return candidate Sanjay Sangma. Who's the return candidate? He is present.
Well, I think the service is not yet complete in the main matters.
It doesn't matter. Your return candidate is there, no? You're for the election petitioner.
Yes.
You have no objection.
No objection, Your Lordship.
What is your name?
P. Sunar, Your Lordship.
P. Sunar.
Yes, Your Lordship.
You record the name of P. Sunar for the respondent number 1. This election petitioner has no objection, like in the other case. Yes. Number 6, yes.
Next is election petition number 6. This is that matter where one particular polling station, the EVMs are in issue.
You have party there?
No,
they're not a party.
Not a party, my lord. We have filed a separate application.
Okay. The same order for intervening, registry to register, and then in the main order, it will be different anymore.
The only issue here is, as your lordships would recollect, I'm grateful your lordships reminded me that these EVMs, they come on those boxes, Melody, the steel boxes.
Steel boxes,
Steel boxes, and if I'm not mistaken, if my memory doesn't fail me, Melody, I think there are 5 EVMs which are stored in one box. 5 balloting units and 5 control units.
Yes.
So Melody, I don't know whether this can be segregated in terms of whatever the application has been filed.
We have specified, my lord.
No, I'll tell you why he has a point.
My lord.
Because they're packed up in one batch.
You know what happened, just out of the record. So what happened was when that matter, when it moved to applications, they kept on bringing all those trunks inside the courtroom.
Your Lordship, which is
we were put to. So,
because, well, if I remember correctly, they come in batches of 5.
Brought in a whole these trunks and they were put in the side of the courtroom.
Well, they come in a batch of 5 and they are sealed together. Because under the handbook of the elections, that trunk is sealed as one seal. So you cannot isolate one.
Actually, it's for one polling station, one trunk, I think.
No,
I'm not mistaken.
No, it's not for one polling station. What happens is, Malaj, these EVMs are randomized. It is done a day before. So what happens is they come on these one boxes, these trunks, as your Lordships rightly said, and Malaj, these are I think 5 in number.
Picked up by someone.
Post elections, Malaj, what happens is that these boxes are again sealed. And there is a procedure for sealing these boxes. If your Lordships recollect, my lords, we had to open those boxes. The seal of the counting officer or the return, it wouldn't be the returning officer, my lords, it will be somebody else who does the sealing. So whether they can be isolated is a question, my lords, I leave it for my friend to answer.
Look, we have indicated the IDs of all the...
No, but then if it involves opening, there should be no question of any tampering that might happen, that's all.
What I'm saying is, my lords, that only with regard to that trunk,
that trunk where that EVMs contain, that shall not be opened.
Yes, my lord.
You can spare 2, 3, 4 EVMs. You don't.
I think the total 5 EVMs come in one trunk.
Can you get instructions on this?
I will get instructions, my lord.
See if it comes, yes. I know, I remember, yes.
Your Lordship will recollect this because we had the arduous task of opening every trunk which is sealed on both sides, and every seal has again a number. And it is marked with a thread.
I remember I had an arduous task of convincing. Then finally, we got it released after 2 years after the elections.
Lord, I'll come back with instructions tomorrow.
Only on that limited issue, my lords, that let those others, I don't have an objection to the others. Tomorrow, that issue should not come up, my lords, that this.
No, of course, no. You cannot take it segregated by itself. The seal be opened only when the time of evidence is taken and when experts are called to examine whether that mock vote, which is entered in EVM, had any impact on the result.
I will ascertain, my lord.
Next, number 7.
Number 7, my lord, we are not parties. Therefore, 2 applications, my lord.
Same thing, number 7, 1A, under Order 1 Rule 8, register, and other one is for release of the machine. You're for the election petitioner.
Yes, ma'am.
And you're for the return candidate. So you record the names of T. Yankee for the return number 1 and Mr. S. Dev for number 2, Rupa Amara. Oh, Rupa Amara is a male. I thought Rupa is a female.
We all thought.
Yes. Okay, and item number 6, in this case, item is record item 6. This is an application under Order 1 Rule 8A, registry to register that. In the what part? Next order in election petition number 6, this is an application under 151. Can you vote the score title? Vote the score title. Next paragraph. As it is not clear as to the manner of storage of the concerned EVM, whether it has been sealed together with other machines which were used in the elections, the counsel for the applicant is directed to obtain instructions on this aspect. This is matter tomorrow, day after. Tomorrow. This is matter tomorrow. Right. So, but Mr. Paul is very right. Now I remember, it just comes flooding back in memory.
Once it fell from your Lordship's well, as it went back and those trunks came back.
Because those trunks were, they were, I don't know why they were brought to the courtroom every time.
Because well, as in those cases we had to examine the individual EVMs with those numbers.
Yes. But the case became infructuous, I think.
Ultimately.
No, because we got stuck.
Because at the end of 4 years I was told to go back and contest on the field.
Right. Thank you.